Hi everyone, this is Latrina Robinson, and I will be reviewing the case of TAMARA SKIDGEL versus the California Insurance Appeals Board. So let's take a quick review of what we'll be discussing. We'll look at the subject of the case, the procedural history and case disposition, questions presented, also known as the issue, additional facts, and the rules or laws discussed. We'll also look at the plaintiff and defendant's arguments, the California Supreme Court holding, the court's reasoning, and we'll end by looking at the takeaways and additional areas of consideration. This case is interesting and it looks at eligibility factors for unemployment insurance, classifications of work for in-home support services when we talk about direct hire versus joint employee, and it also looks at validity of precedent benefit decisions or PBDs. Let's take a look at how this case came to the Supreme Court. This started back in 2014 when the California Unemployment Insurance Appeals Board established a precedent-setting decision regarding in-home support workers caring for family members and their inability to access unemployment insurance. So TAMARA SKIDGEL filed a complaint with the administrative law judge in reference to her inability to access these benefits, and she was denied. She submitted a complaint to the California Unemployment Insurance Appeals Board and was also denied. And in April 2016, she filed to Alameda County Superior Court challenging the validity of the precedent-setting case, also known as the Caldera case. This case was heard by the Alameda Superior Court in April of 2016, and the central issue was should a declaratory relief be issued prohibiting the CUIB's decision of making IHSS family caregivers ineligible for unemployment insurance. The Superior Court did find in the CUIB's favor, and they did not bother themselves with determining the classification of IHS workers, if they're direct hires or joint employees. Instead, the court focused on the unemployment code statutes, persuasive arguments, and precedent-setting cases. And one of the precedent-setting cases it used was the 2015 CUIB case of the matter of Caldera. Now, SKIDGEL did appeal the decision, citing the trial court erred in using that 2015 CUIB precedent-setting decision. So from the Superior Court, the case was heard in the California Court of Appeals, the First Appellate Division, in June of 2018. And the outcome was that the Court of Appeals upheld the decision of the Alameda County Superior Court. And they specifically found that, one, the precedent benefit decision, or the PBB, was affirmed. It also agreed that the Unemployment Insurance Code Section 631 and 683 excluded family IHSS providers from unemployment insurance benefits. And then lastly, it said that any appeals brought forth by SKIDGEL would require that she also paid the cost of the CUIB. And SKIDGEL did appeal and led to the California Supreme Court, which brings us to the court case at present. The court case at present is that of the Supreme Court of California that was heard just recently on August 19, 2021. And the outcome was that the Supreme Court upheld the decisions of the Court of Appeals. It used similar and same case statutes, case law, precedent, and non-precedential decisions were also factors. And the court opinion was authored by Justice Jenkins, and all Chief Justices were in concurrence. So the Supreme Court heard two issues. First issue was, can an in-home support service provider who is a direct hire and a minor child, parent, or spouse of the IHSS recipient be covered by the state's unemployment insurance program? The second issue they heard was, is the CUIAB, the California Unemployment Insurance Board rule that excludes close family members of IHSS providers from unemployment insurance legal? The California Supreme Court looked at several legally relevant facts. They first looked at the early mid-2014 decision of the CUIB. Then the CUIB heard a case of a woman, Ostapinko, who was providing care to her son. The CUIB ruled in her favor and that she was eligible for unemployment insurance, citing that she was a dual employee of both her son and the public authority. That decision was determined to be non-precedent setting. They also explored the secondary authority, or the letters from the California State Department of Social Services and the Unemployment Development Department from 2014, December of 2014, in which they disagreed with the opinion of Ostapinko, and they asked that the case not become precedent setting or not become a PBD. They also looked at the October 15 case of the CUIBD that was a precedent-setting case, or a PBD, and that case indicated that Caldera, who was a caregiver providing care to her son, was not eligible for unemployment benefits based upon provisions of the Unemployment Insurance Code number 631 and 683. Additional facts explored by the court were Tamara SKIDGEL's history. She'd been serving as an in-home support service provider for her daughter since 2013. They also looked at the in-home support services versus workers' comp appeals case from 1984. And that case, in-home support workers were identified as dual employees by both the state and the recipient for matters of workers' comp. And then they also looked at the Welfare Institution Code 12300, which is actually the code that speaks to in-home support services. There are portions of the code that address how recipients are hired, in-home support recipients were hired their providers, and there's also a Department of Social Services manuals that describes the 3 general service delivery methods, whether an employee can be a county employee, a purchase of service employee from an agency, or purchase of service from an individual, also known as the direct payment method. In making their holdings, the court looked at a number of laws and rules. They explored the Unemployment Insurance Code sections 409, and that permits the CUIB, the California Unemployment Appeals Board, to designate its decisions as precedent setting or not precedent setting. And those that become precedent setting are subject to court challenge. It also looked at the Unemployment Insurance Code 409.2, which grants authorization to people or entities to bring a case to the Superior Court if there's a question of the validity of the appeals board's decision. They looked at Employment Insurance Code 631, also known as the Family Employment Exclusion, and the Employment Code 631 stated that work done by someone under the age of 18 for their parents, or work done by someone in for their son, daughter, or spouse is not considered employment from an unemployment insurance perspective unless the employer and the employee contribute to the unemployment compensation fund. So they also looked at the 1935 California law statute as it defined employment, and that statute actually became the Unemployment Insurance Code 631. Other laws explored were the Unemployment Insurance Code 683, also known as the IHSS provision, and it defines an employer as any unit that provides domestic services like in-home support services that are done in accordance with the Child and Welfare Institution Code 12300. And they must also pay $1,000 or more the current and previous quarter a year. It looked at the Ostapinko case of 2014. That case was a non-precedential decision that determined a woman providing in-home support services to her son was a joint employee of both the public entity and her son and was therefore eligible for unemployment insurance. and it explored the matter of Caldera of 2015, in which the CUIAB issued a precedent-setting decision, or a PBD, that said IHSS providers caring for a close family member are under the direct payment mode, and the provider is subject to the exclusion of the Insurance Code 631. They also looked at California Assembly Bill 3028 from 1977, and that's a piece of legislation that made IHSS providers direct hires. They did that as a mechanism of both limiting the cost of IHSS programs so that the providers would not become civil service employees, and also created a mechanism of IHS payroll system. They looked at the Pacific Legal Foundation of Unemployment Insurance case from 1981, and that case really confirmed that the CUIAB has the authority to enact a precedent-setting decision that can eventually become a statute, although it is subject to declaratory relief through the Superior Court system. And then lastly but not least, they looked at Welfare and Institution Code 12302.2, and that code states that if the state or county directly or indirectly pays someone, the recipient has selected, the government entity will manage the employer's taxes and premiums and contributions even though they're not the employer. Now let's look at the arguments set forth by the plaintiff, Ms. SKIDGEL. First, Ms. SKIDGEL said to challenge through judicial intervention the validity of the precedent-setting decision that the CUIAB created that limited family IHS caregivers from receiving unemployment insurance. She also challenged the wording of Unemployment Insurance Code 631, and she said she's not precluded from receiving unemployment insurance, as the coding, the word of the code, implies that she's both a provider, she's an employee of her daughter and the county entity. And then she also challenged the Unemployment Insurance Code 683, stating that by the wording of the code starting off an employer also, it means that she is a dual employer, or else by using the word also. Ms. SKIDGEL also asserted Welfare and Institution Code section 12302.2 and said that as the payroll duties of IHSS are assigned to the state itself, the state has actually become her third employer. She also asserted that for the purposes of workers' comp benefit, the state has viewed IHSS providers as dual employee of both their family member and the state, and they should also do the same for the benefit of unemployment insurance. And then lastly, she said that by excluding IHSS family members from unemployment insurance, then it will create a devastating impact on them as providers. The defendant, in this case the California Unemployment Institution Appeals Board, asserted that the IHSS statutes and the unemployment insurance codes are quite clear, and they state that under the direct payment mode, the IHSS recipient is the sole employer of the provider. They also said that when an IHSS provider is a close family member to the care recipient, they are therefore excluded from unemployment insurance under the Unemployment Code section 631. And as the plaintiff is a direct payment employee of her daughter, and she has a close personal relationship with her daughter, she is therefore excluded from unemployment insurance benefit. The California Supreme Court's holding was quite simple. First, the Supreme Court agreed with the Court of Appeals decision and affirmed the judgment in favor of the California Unemployment Insurance Appeals Board. Second, they indicated that the precedent-setting decision in question relating to in-home support services unemployment insurance codes 631 and 683 that address the family caregiver relationship. And pursuant to Code 631, family caregivers are ineligible for unemployment insurance. So when we look at the court's rationale for their holding, they had several reasons. First and foremost, the precedent-setting decisions, or PBDs, are an agency's mechanisms of rulemaking and offering an expert opinion on an application of law while ultimately leaving statutory discretion to the courts. And the Supreme Court felt that the CUIAB acted accordingly in creating a precedent-setting decision. They also did an additional analysis of AB 3028 from 1977, and they highlighted the legislation's intention for in-home support services were to be direct hires. The legislation was very concerned with the absorbent costs if IHS providers were to become employees or civil service employees. So their intention was to have them always be direct hire employees. And lastly, the court questioned the plaintiff's argument of the dual employer notion. And they said that the dual employer notion is just quite simply invalid. The Uninsurance Code 683 identifies an in-home support service employer as the person who receives funding from the public entity to provide service. So basically, the client themselves is the employer. And they said that there are only 4 methods that a person, a client, can receive funding from the public authority. First is through direct hire. And direct hire is when the in-home support service client receives the funding and direct hires someone to provide the funding in exchange for social welfare funding. Then they themselves become the employer. The second mechanism is through county contracts. That's when a third-party entity is hired or is funded to provide the care. And in that case, the agency, the third-party agency becomes the employer, not the county. The third mechanism is when the county does a direct hire. And in that case, the county is the only employer of the client. And that county hire would fall into the stringent civil service hiring practices. And the fourth aspect is that the county, although it does manage, the state manages the payroll systems due to legislature statutes, the state never said that they were an employer. So there is not a method within the Unemployment Code 683 that a person can have a dual employer. The court also went on to address the plaintiff's assertions that because the state is managing her payroll, taxation, and required financial holdings, that the state is another employer. And the court says that's just not true. The state is simply acting on behalf of her daughter and managing Ms. SKIDGEL's payroll, taxation, and required finances. The court also dismissed the plaintiff's arguments that words in insurance code, in an unemployment insurance code, like also and indicate that there are 2 employers. And the court said that words cannot be looked at as trivial, but instead individual words cannot be looked at, that's trivial, but instead you must look at the totality and grouping of the words and their intent. The court also dismissed the plaintiff's claim that as the workers' compensation identifies in-home support family caregivers as dual employed, that unemployment insurance should also. And the court says that there are times where there is one case but that speaks differently, but the court is not going to affirm the workers' compensation case is applicable to unemployment insurance. And last but not least, the court empathized with the plaintiff's concerns that it's an obligation that the state and the counties have an obligation to protect laws and statutes, and that the family exclusion identified in Unemployment Insurance Code 631 is actually hurting families. The court affirmed that there is case statute in place, that there are measures being taken to support families, and there are also measures being taken to prevent fraud. And the exclusion is a measure taken to prevent fraud. So there are a couple of major takeaways from this case. And some of the major significance are that the SKIDGEL versus CUIAB case It affirmed the inability of family IHSS providers to access unemployment insurance. It also went on to validate the CUIB, the California Unemployment Insurance Appeals Board's role in developing precedent benefit decisions. These PBDs can go on to influence and sometimes create case law. The court also highlighted the CUIB's role in making lasting and affirming decisions and to caution them and their vacillation of thought as they make decisions. Last but not least, there are additional considerations. The court in their holdings gave us a preview of future considerations. The court reminded us that the legislative branch, the lawmaking branch of government, can undergo public interest studies and can enact laws and statutes that change rights and benefits for family IHSS care providers. They also reminded us that there has been ongoing efforts through our legislators, specifically speaking AB 1930 back in 2015 and 2016, that looked at mechanisms to establish an IHSS advisory committee, and with the hopes that the advisory committee can recommend supports and resources to family providers. And last but not least, I, as this reviewer, also wonder what impact COVID-19 will have on future legislative and future court efforts for family IHSS caregivers.